So good morning, everybody. Thank you so much for joining us for our webinar this morning. My name is Leanne King, and I'm the Head of Sales Deployment at LexisNexis South Africa. I'll be facilitating today's session, which is proudly sponsored by Lexis Deceased Estates, our next-gen estate administration solution, which we've recently launched into the market. The topic of our webinar today is essential skills for effective compliance with Section 86 of the Legal Practice Act. And we're very pleased to be hosting this in partnership with the Legal Practitioners Fidelity Fund, or the LPFF. As you're aware, LexisNexis often partners with various organizations equally committed to advancing the rule of law as we are. And the LPFF is one such organization. We'll be looking at some of the requirements for legal practitioners to ensure they are compliant when it comes to Section 86 of the Legal Practice Act, which regulates the trust accounting practices of legal professionals. To provide us with some expert guidance on this topic, we are very pleased to have Robert Barawandi with us today. Robert is the investment executive at the fund and has a strong record of driving investment performance and revenue growth, delivering strategic important objectives of the LPFF. He provides leadership in the management of investments, the formulation and implementation of investment regulations, the co-creation and implementation of regulatory compliant banking products, and the strategic structuring of mutually beneficial stakeholder agreements with the banking industry. If you do have any questions for him during the session, please may I ask you to use the Q&A and not the chat box for the questions for Robert and his panel. So, Robert, welcome, and over to you.
Thank you very much, Leanne, for this opportunity. Thank you very much, Leanne, for this opportunity, and thank you to all the participants who will be participating in this webinar. My name is Robert Barawandi. I think Leanne has just outlined my background and what I do for the fund. And the big item or big responsibility in terms of my role is the engagements of practitioners, because trust interest income is the lifeblood of the legal profession, not just the fund. So we have put together a presentation to you where we could share with you some tips on how you can improve your compliance with Section 86 of the Legal Practice Act. And from that perspective, I'll just load my slides very quickly. And I think we can get started. So the overview of the presentation, I think we have an overview of what the fund does. I think what we do find sometimes there is a confusion between what the fund does and what our sister company, the Legal Practitioners Indemnity Fund does, Insurance Indemnity Fund does. Part A of the presentation, after the overview, is going to cover the requirements of Section 86 of the Legal Practice Act, and we will highlight a few changes and differences between the different types of accounts, the methods of payments, and the benefits of investing surplus trust funds in Section 86(3) accounts. Part B will cover the recoverable and non-recoverable bank charges and how practitioners may maximize refunds of their bank charges. And I'll give further details around that. Part C talks to payments of unknown and unclaimed trust funds. These monies the fund has started receiving them from the inception of the Legal Practice Act. And I'll give you a bit of a background with regards to that. And Part D guides practitioners on how to utilize the new refund of bank charges and audit fees. And Part E will talk to the approach of investing in deceased estates and curatorship bonus trust funds. Then thereafter, we'll have a Q&A for about 15 minutes. Next slide, please. The overview of the fund. Next slide, please. The fund exists to protect consumers of legal services against loss resulting from misappropriation. But what I must also point out is it's only about 0.25% of practitioners who ever misappropriate monies. So my role in the fund is to work with the 99.7% of practitioners who are actually making an effort to contribute to the fund and equally so to the legal profession. We also protect the members of the public in the event of misappropriation, but we also encourage the use of legal services by practitioners in the full knowledge that in the event of misappropriation, the fund will also be providing the required cover to the members of the public. In terms of the Legal Practice Act, we also have statutory obligations that we must meet, which relates to the payment of annual appropriation so that the Legal Practice Council can regulate itself. And additionally, the fund has set up in 1993, it set up the Legal Practitioners Insurance Indemnity Fund, which provides cover to practitioners in the event of negligence. Next slide, please. We also promote the responsiveness of access to claimants by providing information as to the LPFF's existence. So I think the CEO has been working on a big project to ensure that members of the public know of the existence of misappropriation. We also have a motto of trying to protect access and confidence in the administration of justice. As you are all aware, the legal profession is more of an ecosystem where each part performs a critical role in the administration of justice. And we act as a defender of the premier institution of civil society at all times, observing the highest standards of corporate governance. Next slide, please, Leanne. Our board constitutes of 9 members, 5 of whom are legal practitioners, 2 persons designated by the Legal Practice Council, and the Minister of Justice puts in 2 people who are fit and proper persons. The new board was constituted on the 20th of November in 2020. Next slide, please. The overview of what it is that we provide to the legal profession as a whole is safeguarding the public interest against theft and fraud, sponsoring funding of regulatory activities in the legal profession, offering bursaries and grants to students at law faculties, providing financial support to lead initiatives and deliverables publication costs, providing inspection services to regulators in large complex matters, refunds of recoverable bank charges in terms of Section 57(2)(a) of the Legal Practice Act, refund of audit fees relating to the audit of legal practitioners' trust accounts, and protecting attorneys and advocates with professional indemnity cover. Next slide, please. So to finance everything that I've just outlined, the fund over the past 15 years has spent 1.3 billion rand, which is part of what the trust interest that is earned by the fund, in providing practitioner support. We've also spent 2.4 billion on regulatory support, 927 million, which was spent on bursaries and law students, and 2.4 billion was paid to the regulators of the legal profession. And claims, which is the reason why we actually exist, the fund has paid a total of 1.7 billion over the past 15 years. The number of claims lodged over that period was 7,650, which was actually paid, but the number of claims lodged was actually higher because some of the claims were rejected. But as of the 31st of December 2021, the contingent liability of the fund stood at just over 1 billion. So this is what is the interest that is earned is used to actually finance and pay over claims for the fund. It's the primary function of the fund. Next slide, please. So from the revenue side, the overview that is projected before you, you will note that in 2019, the fund received a total of 780 million. And in 2020, the fund received 443 million. And in 2021, the fund received 276 million. And these monies are arising from Section 86, 2, 3, and 4, which I'll cover in the later part of this presentation. Next slide. Next slide, P. So what are the requirements for compliance with Section 86? of the trust account. Practitioners are required to have a valid Fidelity Fund certificate before they operate any trust account. So Section 86(1) of the Legal Practice Act says that every practitioner referred to Section 84(1) must operate a trust account. And every practicing legal practitioner must have a valid Fidelity Fund certificate in order to practice and handle funds from a client and for clients, and it is an offense in terms of Section 93(8), read with Section 86(1) of the Legal Practice Act, to practice without a Fidelity Fund certificate. In recent years, on an annual basis, there are normally about 2,500 practitioners who will be practicing without a Fidelity Fund certificate. Currently, I think the Legal Practice Council, together with the fund, are putting in place mechanism of trying to engage or take those practitioners to court, but it's a process that is being addressed by the Legal Practice Council, as well as the Legal Practitioners Fidelity Fund. So trust accounts must be held at a bank that have had, every trust account mentioned above must be held at a bank that has entered into a banking arrangement with the fund in terms of Section 63(1)(g). So the accounts I've made reference to, which is Section 86(2), Section 86(3), and Section 86(4), those accounts must be held with banks that have entered into a banking arrangement. I'll expand on this a bit further in the presentation. But currently what we are experiencing within the profession, there are trust account practices that are holding Section 86(2) and 3 accounts with independent financial advisors who utilize the bank's platforms, third-party administration platforms. The practitioners may do that, but the interest, the IFAs must not set off the interest end as a management fee before paying over that particular interest, because 100% of the interest that is generated on the trust accounts vests with the fund the moment it is generated. Next slide, please. So the comparison between the various types of accounts, I think, is a very big issue from queries that the fund receives. We have Section 86(2). You can consider that more of a transactional account whereby the practitioner receives the daily transactions that are related to trust accounts. And the description that the money is held or received on behalf of any person or company or anybody else that the practitioner is holding trust money. Is there a requirement for the mandate for that? The answer is no. If interest earned in that particular account, 100% of it vests with the fund. And that interest may be paid over to the fund on a monthly basis. It must be paid over to the fund on a monthly basis. And the VAT treatment of the recoverable bank charges that are associated with the trust account, if a trust account practice is a VAT registered, and the recoverable bank charges net of VAT can be offset against the trust interest. For a trust account practice not registered for VAT, the full amount of the recoverable bank charge can be offset against the trust interest. In terms of the protection by the fund, in the event of misappropriation, the fund does cover those monies in the event of misappropriation. Methods of payments, there are 2 methods of payment. The fund, since 2008, introduced what is called the automated monthly transfer system. And there are various banks that operate the automated monthly transfer system, and practitioners, there are several practitioners, a lot of practitioners are participating on that particular platform. 50% of the fund's revenue is paid over via the automated monthly transfer system. Practitioners may also pay the interest manually on a monthly basis. This sometimes poses challenges because sometimes there are delays in the payments. And to that effect, there are conversations of trying to ensure that all interest paid to the fund is actually automated, since manual payments are also associated with compliance costs in the event that the fund or the Legal Practice Council needs to follow through practitioners who might not have paid the interest as and when it is due. In terms of Section 86(3), this money is not specific to a client, and the funds are held in a trust account, and the practitioner then may choose to invest that money in a Section 86(3) account. In general, a Section 86(3) account attracts about 250 basis points, which is 2.5% more than what a practitioner would earn in a Section 86(2) account. But I will amplify on that later on the benefits of using this type of account in a practice. In terms of the mandate, there is no client mandate. In terms of the interest earned, 100% of that interest and vests with the fund, and interest accrued in terms of any specific period on the last day of February in each year shall or before the last day of May in that year be paid to the fund less recoverable bank charges. The VAT treatment is the same as referred to above, and banks rarely levy bank charges against Section 86(3) account. I think that's the distinction factor between, in terms of VAT, between Section 86(2) and 3. In the event of misappropriation, practitioners will fully be reimbursed by the fund. The automated monthly transfer systems, not all banks have these manual payments. So we'll move on now to Section 86(4). Section 86(4), money for a specific client for legal services. In terms of Section 86(4), in most cases, you have an underlying mandate that actually is asking the practitioners to invest those monies on behalf of the member of the public or their client. And clients' mandate are required prior to the investment. 5%, the distinction here is an important one. Only 5% of the interest generated from Section 86(4) account vests with the fund. In terms of Section 86(5)(b) of the Legal Practice Act. VAT is not applicable. In terms of this, it's applicable to the client of the practitioner. Protection of the fund does provide protection in the event of misappropriation. The method of payment, by design, we deliberately engage the banking industry because Section 86(4) is a new type of account. We engage the banking industry to ensure that automatic sweeping and there's no manual payments in that area. And I think we are about 99 of the successful. We've been very successful in that regard because 99% of the interest paid from Section 86(4) account is all via automated monthly sweeps. Next slide, please, Leanne. The banking arrangements that the fund has entered into 13 banking arrangements. So the banks before you are the ones that have a banking arrangement with the fund. Practitioners may not place any particular trust deposits or otherwise with any bank that has not been entered into a banking arrangement with. So these are the banks that the fund has banking arrangements with. Next slide, please, Leanne. Payment of trust interest in terms of Section 86(2) and 3. The method of payment of trust interest is the automated monthly transfer system, and the option elected by legal practitioners and is not compulsory. So practitioners can choose to be on the automated monthly transfer system or can choose to pay manually. But currently, as I'm indicating from a policy perspective, we are moving towards more of an automated monthly payment system. So we'll be working together with the Treasury Committee and the board to see the opportunity around the automated sweeps on all trust accounts, thereby removing manual payments. When interest is paid manually, the practitioner must ensure that it is paid to the right account, which is that of the fund, and proof of payment and the relevant documentation must be sent to the LPA reports at fitfund.co.za. The reporting templates are available from the LPFF. At the end of the presentation, I'll give names of details that practitioners can log in or contact the fund to get any assistance with regards to the issues that I'm addressing in this presentation. Issues of non-compliance with Rule 54.14.16.1 and 54.14.16.3. Trust interest payments made by legal practitioners using incorrect banking accounts. This is what we are coming across in most of the work that we are doing. There are a few examples of non-compliance reported in the audit reports have been noted. We are engaging with SICA and EBA to ensure that the auditors report on any non-compliance noted during the annual audit. So in the event of non-compliance, this delays the payments of refunds as well to practitioners. So it's easier to have a clean audit that is done once off and you submit your audit refund and bank charges application to the fund. It shortens the time period for you to receive your refund. Next slide, please. Thanks, Leanne. Section 86.3, as I indicated earlier, the interest earned on Section 86.3 is 250 basis points, 2.5% more than what you earn in Section 86.2 accounts. So most practitioners, through the Trust Interest Portfolio team that works with practitioners across the country, move a portion of their balances from Section 86.2. So for example, if you're holding R1 million in Section 86.2 account, they're typically encouraged to deposit 50% of that in a Section 86.3 account, and you earn additional yield of 250 basis points in all interest rate cycles. But given the fact that interest rates are still relatively low, you will tend to benefit quite significantly from the refunds of bank charges from the fund and audit fees, should you be utilizing the Section 86.3 accounts. So this is something that we have applied since 2016. And to date, we have balances, confirmed balances of about over 500 million that practitioners who are actively using Section 86.3 accounts. We do plan to scale this particular proposition, but it will also lead to the revision of the annual refund formula calculation that is currently in place. So we are really strongly encouraging practitioners to make use of Section 86.3 accounts. And the benefits of using that as articulated here, one is that the increased trust interest income for the fund, for the practitioner and the fund as well, and increased refund of audits, and increased trust interest income to offset the recoverable bank charges, and the ability to manage your cash flow by being able to offset your previous month's excess recoverable bank charges against your Section 86.3. Next slide, please, Leanne. Here's an illustration that I use with the team to illustrate the benefits. So if in your practice you have a R1 million deposit in a Section 86.2 account, if that deposit is earning 0.7%, the interest you generate if you hold that deposit for a year is 7,000 Rand. But on the same deposit, if you place it in a Section 86.3 account, you will earn interest of 27,500, assuming you've held that balance for over a year. And if you compare that to a Section 86.4 account, whereby there is a mandate, you only earn about 1,700. The fund will earn about 1,375 in interest. So the benefits of Section 86.3 account are quite obvious. They are 4 times as much in terms of interest compared to using a Section 86.2 account. So most practitioners would choose to just put their working capital in a Section 86.2 account based on their needs. And then they will move that the balances to Section 86.3, and from there on they will earn a significant interest. From the fund side as a business, we monitored the balances in a Section 80, let's not call it a Section 86.2 because we don't know what Section 82, in our current account, in money market account. So you can say Section 86.2 is a current account. The Section 86.3 is more of a money market call account, as an example. And within a year, we're able to earn additional 3 million Rand by mostly ensuring that our Section 86.2 did not have significant balances, and we're putting the money towards the Section 86.3 account. And the interest was quite substantial, to the tune of 3 million Rand within a year. So for practitioners, the benefit here is that it will contribute quite significantly to what will be recoverable bank charges and audit fees. Next slide, please. This is an example that has been articulated between interest earned on a practitioner who's not using a Section 86.3 account, and on the right-hand side where you have the orange bar is a practitioner who's using Section 86.3. So there's a split if you look at under the orange bar. Section 86.2, the balance there is 37,000. The interest earned there will be 37,000 on a particular notional balance. And Section 86.3, the balance there, the interest earned there will be 56,000. But the subtotal of interest across the Section 86.2, 3, and 4 accounts, you will see that the practitioner who's using a Section 86.3 account who has a superior balance of 122,000 compared to 103,000. And the benefits in terms of the audit refunds, you'll see that the practitioner who does not use an Section 86.3 account will only be refunded 17,000 compared to a practitioner who's used a Section 86.3 account who will be refunded 21,000. So those are the benefits from a practitioner who's moved 50% of their balances into a Section 86.3 account. Next slide, please. The proper designation of trust accounts is something also that we do come across. It is important that practitioners properly designate their accounts. Section 86.2, Section 86.3, and Section 86.4, especially when they go open those particular accounts with financial institutions. The impact of Section 86.5A and B, when a trust account is not properly designated, is quite significant. Section 86.4, a trust account that has been incorrectly designated as Section 86.3, the 100% of that interest will vest with the fund and will be paid over to the fund. So you will end up having an instance whereby your client will be totally unhappy because they haven't earned any interest despite them having given you a mandate. So the designation of that particular account, the trust account in general, is also equally important. Next slide, please, Leanne. Part B, recoverable and non-recoverable bank charges. Next slide, please. I'll try and speed up. I know I'm very conscious of time. In terms of the Legal Practice Act, Section 57.2A, subject to the provision of this Act, the fund may be utilized for the following purposes. One of them is the reimbursement of bank charges. And from the fund size, we have designed what we call refundable and non-refundable bank charges. So recoverable bank charges is the monthly basic fee on the trust account, which is the typical Section 86.2, electronic payment fee, electronic payment systems, monthly subscriptions, unidentifiable deposits, trace fee, which the bond bank sometimes charges, cash deposit fees, and cash handling fees. And the treatment of VAT of those particular accounts is that trust account practice that are registered as VAT vendors, the recoverable bank charges excluding VAT should be deducted from the interest. And trust account practices not registered VAT vendors, recoverable bank charges including VAT may be deducted from the trust account. Next slide, please, Leanne. Yeah, I see a lot of questions are coming through. The slides are going to be shared with all of you after the presentation, but equally so, my colleagues are also trying to answer the questions that they can answer as the presentation is proceeding. So the issues of non-compliance that we do encounter, trust account practice are not deducting subscriptions and fees associated with third-party rental collections for legal practitioners and property practitioners. We're also coming across trust account practices deducting subscriptions and fees associated with third-party rental collections for legal practitioners and property practitioners. Another issue has to do with the non-recoverable bank charges claimed against trust interest by trust account practices. Trust account practices who are on the automated monthly transfer system must ensure that only recoverable bank charges are deducted from the trust interest when completing the legal practitioner's annual statement of trust accounts, irrespective of what bank charges the bank have offset when making the payment to the fund. Next slide, please, Dean. Part C deals with payments of unknown and unclaimed trust money. Next slide, please. So from the fund side, we have received unclaimed and unknown trust funds since August 2006. And that was by means of a board resolution. And up to the end of November in 2018, the fund had received a total of 150 million in unclaimed trust monies. And to date, that money is at the end of the first quarter of this year. The total unclaimed monies held by the fund stood at 273 million. So before November 1, it was recommended that unknown or unclaimed trust money be paid over to the fund. And from November 1, 2018, payment of trust fund unclaimed and unidentifiable and unclaimed trust money became compulsory. So Section 87.4 addresses on how those monies should be paid over to the fund. And those monies must not be, the payment of that monies must not be applied retrospectively in respect of deposits made prior to the 1st of November. Trust account practice with the financial reporting period ending on or after 30th of November 2020 are required to comply with the requirements of Section 86.4a. An example has been articulated here. A trust account practice with the February financial year end received an unknown deposit of 75,000 on 25 August 2021. The question is then, when should the 75,000 be paid over to the fund, or should it remain unknown and unclaimed? So after 28 February 2023, but before the end of 2024, that is when the monies must be paid over to the fund. Do these trust funds form part of the fund's assets? The answer, this is a frequently asked question that we do come across. These monies do not form part of the fund's assets. They are ring-fenced. They are held in a money market account. There's basically no risk. They do earn interest, and they do not form part of the fund's assets. The process to pay unknown and unclaimed trust funds to the fund has been articulated and shared with the legal profession, and we do refer you to a published article, which you can find on the fund's website. Next slide, please. Part D deals with a new form, which is a revised application form for the refund of bank charges and audit fees. Next slide, please. So from the fund size, we've put in place the application. We've put in place a new refund application that takes into account interest and in terms of Section 86.5a and b. Previously, refunds were only made in terms of Section 86.2 and 3, but through the board and the board resolution, the board felt that it is a fair process to add Section 86.5 because it all relates to interest. So practitioners have the benefit of aggregating all interest earned in terms of Section 86.2, 3, and Section 86.5 A and B when they are submitting the refund application for refund. The form can be completed digitally. I think we've just developed that during the course of this year. Members of my team have developed that, and this applies to refund applications from trust account practices with financial periods ending after 1 March 2021. The forms can be found on the fund's website. I think it's fairly easy. If you go to the fund's website that deals with trust accounts, you'll find the form there. Tips to avoid delays in receiving of your trust funds. This is a big issue because sometimes practitioners use the process of the refund that they receive from the fund to settle their audit fees with their auditors. So what we want to do is to ensure that we submit a correctly completed refund application form so that you can also receive your payment seamlessly. So things to avoid delays in receiving your refunds. Trust account practices are encouraged to submit an application of refund or bank charges and audit fees together with the auditor's report. So those things should come together. The application of refund of bank charges and audit fees form must be submitted to the relevant provincial council. If no refund application is submitted, no refund will be received. The fund is reviewing the process to try and enhance how we're currently doing that, as I indicated earlier. But in general, on an annual basis, only about 6,500 of practitioners, 6,500 practices ever qualify for a refund. And to increase that number, the use of Section 86.3 is key for practitioners to use. Next slide, please, Ian. Part E addresses the approach to investing deceased estates and the curator bonus of trust funds. Next slide, please. So from the approach of investing deceased estates and curator bonus accounts, here we are highlighting that a legal practitioner has a choice of either investing deceased estates fund in terms of Section 86.4 of the Legal Practice Act or through Section 28 of the Administration of Deceased Estates Act. But there are differences. If you invest that money in terms of Section 86.4 of the Legal Practice Act, investments are the investments are treated as follows. The deceased estate funds generally flow through the legal practitioners trust accounts before being invested in terms of Section 86(4). The interest accrued is subject to the 5% deduction in terms of Section 85B of the Legal Practice Act. But if you do use Section 28 of the Administration of Deceased Act, the investments are treated as follows. The deceased estate funds generally do not flow through the legal practitioner's trust account. I think that's the distinction there, before being invested in terms of Section 86(4). The interest accrued is not subject to the 5% in terms of Section 85B of the Legal Practice Act. But in the event of misappropriation, it's also one of the key strategic issues that the fund is currently considering. In the event of misappropriation, the fund does pay over those, and if there was entrustment, the fund does provide cover to those monies, regardless of how they had been invested. I think next slide, please. Yeah, I think we've reached the end of the presentation. I think I'm 1 minute over. I'm supposed to finish at 22. So I think Leanne will open the floor for questions.
Yes, thank you very much, Robert, for the informative address that you've just given us. I'm sure our attendees found that very insightful. Just a reminder to please use the Q&A tab at the bottom of the screen rather than the chat box for your questions. And then we'll get to these questions in a minute. So you'll see a poll coming up onto the screen. And if you don't mind just taking a few seconds to complete this poll, we'll give you a few seconds to complete that, and then we'll move on to the questions. Okay, so Robert, before we get into the questions, I just wanted to understand, what is the number of practitioners who receive their audit refunds within a month of submitting them? Robert?
Sorry, just repeat the question, please.
What is the number of practitioners who receive their audit refunds within a month of submitting them?
Yeah, typically from the fund, we have a rule. Obviously, the refund application has to go via the Legal Practice Council, the fund. But when it eventually reaches the fund, that means the refund has been reviewed, and the fund will then pay that within a week of receiving it. So I think the majority of practitioners receive their refund application within a month of submitting it. But if the funds are not, the refund application is not completed properly, you end up having a situation whereby there are lots of to's and fro's between the fund and the practitioner, or the legal practice and the practitioner, and that delays the payment of the particular refund. So if the audit process is done properly, you end up getting your refund quite seamlessly, and the majority of the refunds are settled within the month of submitting them.
Okay, thank you so much. What kind of support does the fund offer to newly registered firms?
Yeah, the fund, typically, I think the fund offers a good footprint in terms of the setting up of the practice. There's a compliance team that assists practitioners with better complying with the provision. We provide legal education for further training for practitioners. And there are lots of other initiatives that we do provide to the practitioners in terms of establishing their footprint, especially on the training side. Since the fund funds legal education, it also tries to ensure that practitioners have a good footing when they start their practices, because profitable practices are good for the practitioner and equally so for the legal profession as a whole.
Absolutely. Okay. Thank you, Robert. Can bank charges be offset against the interest of another Section 86 account held by the same firm?
Yes, I think the practice within the industry has been the consolidation of those particular accounts. So the practices would aggregate the trust interest earned on those particular accounts, then they will offset that as a whole. I think that, so there's an aggregation process that takes place between the bank charges. So let's say we have Bank A and Bank B and Bank C. So the practice is holding three different accounts at three different banks. What will typically happen is that they aggregate the interest, then they will offset the bank charges against the aggregated interest.
Okay. In the event that a trust account does not earn sufficient interest to cover the bank charges, and the bank charges have been covered by the business, can the business recover the bank charges from the interest earned on another Section 86(2) account? And can this be done monthly?
That has traditionally been done on an annual basis. But I think some practices do practice that. There are months whereby practitioners have to pay into the trust account because the trust account did not generate adequate interest. But the bank charges has to be subject to the interest earned in the practice at the end of the year when they submit their refunds. Currently, it's not monthly, it's not done monthly. Okay,
thank you very much. Then Michelle's asking, please can you give a practical example of the use of Section 86(3)? I'm not clear on when this would apply, as I thought we could only hold funds in trust that are for a specific client.
Okay, normally if the current account is an account that you receive the monies into, so practitioners, where any monies that are paid into Section 86(4) has to go through a Section 86(2) account. So a Section 86(2) account is the primary trust account for a practice. So when monies are paid into a Section 86(2) account, the member of the public, you could be holding the money in trust for another reason, but let's say there's a particular mandate. When you receive that money in a Section 86(2) account, in the absence of a mandate, you may invest those monies in a Section 86(3) account because there's no particular mandate that is saying you should invest those monies in a Section 86(4). But if you have a specific mandate, even the overnight balances that whereby there's a time delay, let's say you receive the money at 3 p.m. and you're only able to open the Section 86(4) account in the following day, the overnight balance generates interest and that interest vests with the fund. But whereby there's no specific mandates, practitioners typically invest those monies in Section 86(3) account. And I think that's why it was introduced. Okay. So the mandate is the distinguishing factor. So 100% of interest earned in Section 86(2) vests with the fund. 100% of interest earned in Section 86(3) vests with the fund. And there's no mandate that is required to invest monies in Section 86(3). So the interest all comes to the fund. But whereby you have received a mandate, you have a duty to open a Section 86(4) account in the name of your client, and only 5% of that interest comes to the fund.
Okay, thank you for answering that. How does one open the various accounts practically in practice?
Okay, you just have to speak to your banker. Your typical banker can assist you setting up with a Section 86(3) account. All the 13 banks that have entered into the banking arrangements with that offer, not all of them offer Section 86(3) account, can easily do that from your office. In most cases, I think once you set that account, then it's up to you. You can choose to make the investment, whether on a daily basis. From the fund side, I can give you an example, a practical thing that has worked. On the example that I gave in the presentation, I receive the balances contained in our current account, which is a Section 86(2) equivalent, and balances in a Section 86(3) account on a daily basis. So I get to understand that the balance in a current account, which is the Section 86(2), if you're looking at a practice, is very big for today. And it's all it takes is just to move 50% of that or 75% of that into a Section 86(3) account. And if you need that liquidity, we move it back to a Section 86(2) account. The interest generated over a year from the fund side is over 3 million rand just by merely applying that. So you can do that on a daily basis. First time you get in the morning, just check where your balances are at, what are your operations for the day, and what it is that you don't need. And I think that's where the movement comes in. And there are typically no bank charges associated with depositing the money into a Section 86.3 account or bringing it back into a Section 86.2 account.
Okay. Percentage of interest earned is taken by a legal practitioner?
Sorry, repeat the question. My apologies, Leanne.
No. What percentage of interest earned is taken by a legal practitioner?
No, a legal practitioner cannot take any interest at all. So 100% of Section 86.2 interest vests with the fund, and 100% of interest earned in terms of Section 86.3 vests with the fund, and 5% of interest earned in terms of 5% of interest earned in Section 86.4 accounts also vests with the fund. The 95% of interest earned in terms of Section 86.4 is for the client of the attorney. And the practitioner may charge an administration fee to the client, but all interest that is generated in terms of Section 86.2 and 3 vests with the fund, and 5% of that, of the interest earned in terms of Section 86.4 also vests with the fund. Practitioners are not entitled to any of that interest. Practitioners may get a reimbursement of some sort if they've generated adequate interest that is in excess of their bank charges and audit fees subject to a formula, and only then are you reimbursed for the recoverable bank charges and a portion or some of the audit fees. But in the absence of that, all interest vests with the fund, and practitioners are not entitled to any portion of that.
Okay, thanks, Robert.
Yeah.
Kim Kirby from AMC Hunter would like to know if the trust bank charges are allowed to flow through their business accounts, or do they have to flow through the trust accounts?
They have to flow through the trust accounts, because when the trust account is audited, that's what the auditor will be looking for.
Okay, thank you very much. Okay, why can a card machine charges not be claimed from the interest earned?
It's a good question. It's a 20-year-old question as well. I think the card machine is viewed as part of the business. The business is providing a particular convenience to their clients. So it's never been party to, it's been presented on several occasions to the Treasury Committee. And I think the position is still that it's the convenience that the practice provides to their clients, not necessarily for the fund. So that it does not form the list of recoverable bank charges.
Okay, and then Michelle just wants to clarify, can Nedbank's monthly maintenance charge be deducted against the interest, or should this be a business account debit?
Just repeat the question, please.
Just to clarify, can Nedbank's monthly maintenance charge be deducted against the interest, or should this be a business account debit?
Yeah, the problem that we try to address, I'll answer the question, but let me just give the context. Sometimes when a practitioner has a business banking account and a trust account with one bank, there's sometimes the bundling of bank charges. I think it makes it more difficult to separate on which charges are close to what. So I think the best reference point is to look at the list of the recoverable and non-recoverable bank charges. I think that's where the answer will be. If you look at the list of recoverable and non-recoverable bank charges, you are able to distinguish which charges are recoverable and which ones are not recoverable. So the ones that are not recoverable are for the business account, if that answers Michelle's question.
Thank you, Robert. Just checking through these questions here. So what is the difference between a Section 86.3 and a Section 86.4 account, and should law firms have to choose between the two?
Okay, I'll make the distinction first. I'll start with Section 86.2 because this is a very important point. Section 86.2 is more of a current account, and 100% of the interest vests with the fund. A Section 86.3 account is more of an investment account, but it's investments of monies that do not have a name to them. There is no underlying transaction, or the practitioner has not received a mandate to invest those monies. And 100% of interest earned in that account also vests with the fund. So to make the distinction between Section 86.3 and 4, Section 86.3, there is no mandate that is given by a member of the public of those monies that are being invested there. That's one. And secondly, Section 86.3 earns a better interest for the practitioner and the fund in terms of interest earned. So it provides a very good benefit when the practitioner eventually lodges the application for a refund of bank charges and audit fees. But Section 86.4 is different. So what happens in Section 86.4? Leanne is buying a house. She makes a particular deposit with the practitioner, and Leanne asks that particular practitioner to invest those monies in terms of Section 86.4. That's how the mandate arises. So Leanne takes that money. It will have flown through into a Section 86.2 account first. Then Leanne then opens an account in terms of Section 86.4, which is in the name of Leanne. So it's being held in trust in the name of Leanne. But the interest that is earned on that deposit of Leanne, 5% of it comes to the fund, and 95% of that interest goes to Leanne. I think that's the distinction. So you can track it in terms of where the percentage of interest that accrues to the fund. 5% of interest of the interest goes to the fund in terms of Section 86.4, and 100% of the interest earned in terms of Section 86.3 comes to the fund. And Section 86.4 requires a mandate for you to invest that money from your client, from Leanne, in this example that I'm trying to give.
Okay, thank you very much. Just being a bit mindful of time, Josie, do we carry on with more questions, or?
You're welcome to carry on. Thank you, Leanne and Robert.
Okie dokes. And I'm just seeing who's not typing on one. Okay, what is the benefit of opening a Section 86.3 account? If I am understanding correctly, the funds invested will be that of the practitioner and all interest accrues to the fund. It seems to be additional admin for the practitioner with no benefit, or did I miss something? For a small practice where the practitioner attends to all aspects of the practice, it does not seem to be a worthwhile option.
It is a worthwhile option. It is a very, very worthwhile option.
That's from Anonymous.
No, you don't need to be anonymous. I think it is a worthwhile option. The reason for this webinar is essential skills for effective compliance with Section 86 of the Legal Practice Act. So what we are trying to demonstrate are particular opportunities that practitioners may exploit in terms of their practice. So from Anonymous, in terms of the administration, we do understand the profile. About 80% of practitioners in the country are single practitioners. So there are banks that offer an automated mechanism of actually doing the Section 86.2 and 3. So if you inquire with your bank, you can find a solution that removes the particular admin. So from the fund side, if I explain that, if you receive when you get into the office first thing in the morning, 7:30, you just receive a schedule that tells you what were your closing balances from the previous day, and you know exactly what is your position. So if you see the current account, which is Section 86.2, increasing in value, you can move those monies. You don't have to do it on a daily basis. You could do it weekly or monthly, but the benefits are quite significant when it comes to the refund of audit fees and bank charges. As I indicated, only about 6,500 practitioners ever submit or qualify for a refund of audit fees and bank charges. So from a business perspective, just imagine if your bank charges are going to be covered by the fund, the recoverable ones, and equally so part of the whole of your audit fees are being covered by the fund. You can only achieve that if you are generating adequate interest to cover those. So there are benefits to practitioners in spite of the admin. The admin, you can go the route of automating it or finding suitable banking products that reduce that particular admin.
Thanks for that clarity, Robert. The last three questions, I know we are out of time at the moment. Josie, must I carry on with the last three questions?
These can be the final three. Thank you, Leanne.
Okay, final three, so that's perfect. In the example of the Leanne and the deposit, is that not a Section 86.2 account? And what then is a Section 86.2 account?
Okay. When you open a practice, you are required to, the first account you open is a Section 86.2 account, because it's where you are going to do your initial transaction. If I become your client and I have to pay money in trust, it's that type of account that I'm going to pay into. But once you have settled, you may open a Section 86.3 if you want to generate more interest so that you can qualify for bank charges and audit refunds at the end of the year. But if Leanne then comes to you to say, I'm buying a house, this is the 200,000 Rand deposit, I want you to open a Section 86.4 account for me. Leanne will do that because she wants to get the 95% of the interest. But Leanne is also fully aware that in event of misappropriation, in the rare event of misappropriation, she's also covered by the fund. So I think that's why then the other accounts are more secondary. So your primary account will be a Section 86.2 account. So if you're also paying out Leanne the deposit or paying the seller of the house when the deposit time comes, or the attorneys, the Section 86.4 account payment can only be made through a Section 86.2 account. So you can't pay out of a Section 86.2 account. That money has to go into Section 86.2 account before it is paid out. So your Section 86.2 account is your primary account that you operate. It's more like your check account that you have. So you could have another investment at a personal level, and not as an attorney, as an individual. You could have your check account where you do run your transactions, your debit orders, and you can say a Section 86.3 is some money you are saving in a fixed deposit, the call account, and so forth. So I think that's the distinction. Section 86.2 is a primary trust account. Section 86.3 is an investment account, but the interest on those two accounts, 100% of it vests with the fund. And Section 86.4 is an investment account, but 95% of that interest goes to the client. So you are required to have a mandate. I think that's the distinction. So I think once we share these slides, you can just look at, let's tell you now. Slide 12 captures the distinction between the different types of accounts. But I think it's important to know the distinction between those accounts. And we also highlighted the issue of saying, when you do invest those monies, you gotta be clear which account is which. Because if you mix them up, you are most likely going to fall foul with your client, whereby the interest has been paid over to the fund, but we're supposed to have a Section 86.4. So 100% of the interest has come to the fund. So I think the distinction is clearly on slide 12, which Leanne will share after the presentation.
Fabulous. So question then, good day. There was mention about informing us about investing trust funds with independent financial advisors. How does one do so in terms of Section 86.4 if the client desires higher interest rates?
Yeah, there's only one bank that we know that is currently utilizing that. And the bank is Investec. I think that's where we have evidence of that. We are also trying to learn how actually the independent financial advisors are operating. There are various of them that have different business models. But even if that is the case, because the independent financial advisors are using the platform of a bank, so it's still within the ambit of the bank. But 100% of the interest earned in that case, in those instances, the independent financial advisor may not deduct their administration fees or otherwise from the interest that is generated if that interest vests with the fund. I don't know if I've answered that question.
I think you've covered that very well. Thank you, Robert. Thank you so much for your time. I think there were a few more questions, but we can answer those in emails to the participants. just in respect of time. So in terms of closing, Robert, I just want to thank you again for this great opportunity to share this information and to answer the questions. Thank you to our amazing audience for their participation. It has really been a very interactive session. So thank you everybody for the part you played in that. So we've reached the end of the day, and we will be sending you the webinar recording. So that will be coming in an email to you, as well as information about access to the slides. I think we're just going to make sure we got a little bit more clarity based on some of the questions, bringing in some of the questions to that. We'll be able to update that and send that out to everybody, which would be fantastic. Then you can also now see some information on screen. So just introducing our estate administration solution, which we recently launched into the market. We're very excited about it. It's an online product, very cost effective. You only pay for the matters you load. And we're getting lots of great customer feedback, and we're working together with our customers to produce this really exciting new piece of software. So look out for that, and contact your sales at lexisnexis.co.za for more information, and sign up and give it a try and give us feedback. So you'll be, once you've signed up, you'll actually just become part of the update notification emails, and you'll see as we enhance and deliver more on that product. Very exciting product. In addition, we're pleased to offer today's webinar delegates a discount on the following print works. So of Admin of Estates, Wills and Trusts, Trust Law and Practice, Fundamentals of SA Trust Law. You'll receive a discount code on email from us shortly after this webinar. And please do stay tuned and sign up for updates on upcoming webinars from LexisNexis. Stay safe and well. Thank you everybody for your attention. Thank you, Robert, and to the rest of the Fidelity Fund crew in the background helping to answer the questions as well. Thank you very much. Good day.
Thank you so much.